Good morning. I think mic's working okay. I think from the script I'm supposed to start this morning. I'm surrounded by the heavyweights, and I assume that those little easels up there, oh, that's what she'll point to. Good, because you didn't have that in my script, and so bright is not in there. I wouldn't know what to do. I want to thank all of you all for coming. I want to introduce the people who are with me today. Attorney General Greg Abbott, who I'm sure you know, Representative Kenny Marchant, and Ms. Denny Crawford, who is the Texas Securities Commissioner. We're here because Representative Marchant and I have filed, or will file shortly, I assume, Kenny, I'm not sure how that works, some legislation that is landmark in nature for the state of Texas, and even more importantly, vital to consumers' confidence for all Texans. We filed two bills that will strengthen the corporate integrity of Texas business. We all remember what happened last year with Enron, WorldCom, and other corporate scandals in Texas and around the country. The eyes of the nation were and remain on the state of Texas. The WorldCom scandal alone cost Texas funds about $93 million. The taxpayers of this state cannot afford another hit of this magnitude. The legislation is two-pronged. One, it will increase vigilance over our corporations, and B, increase the punishment of corporate malfeasance. Here to explain the first part of the legislation is the Attorney General. That's why we put him in the middle, Attorney General Greg Abbott.
Thank you very much. I appreciate the somewhat question your reference to the comment that you're next to heavyweights. I am on a diet right now, Senator Ellis, and I'm trying to lose weight a little bit. But let me start out by congratulating and commending Senator Ellis and Representative Marchant for your efforts to help protect the pocketbooks of Texans. This is an issue that's vitally important to the future of Texas to ensure corporate responsibility, and I appreciate your focus on this keen issue. I appreciate also the opportunity that you all are giving me to create the Corporate Integrity Unit and the Office of Attorney General. It's an issue that I campaigned on, wanting to create either a new division or a new unit in my office, and this legislation gives me that opportunity that will allow me to focus on these issues that will be so critically important going forward to ensure that Texas has the kind of corporate integrity that not only is going to hold corporate wrongdoers accountable, and not only going to ensure that investors are going to be more secure going forward, but hopefully will create the kind of environment that is going to attract business and attract people to the state of Texas in the future. A few minor details about the legislation of what it does for me in my office is that it allows me to work with district attorneys and county attorneys around the state in both investigating and prosecuting corporate crime. It also enables me to assist a variety of state agencies with the investigation and the enforcement of corporate crime here in Texas. And the unit also allows my office to become a clearinghouse for information related to corporate crimes. The Open Corporations Law is also helpful because it requires that companies doing business with Texas must reveal any financial irregularities, as well as submit to regular audits with penalties for non-compliance. Last and importantly, all corporate officials responsible for financial statements in Texas will face felony prosecution if they knowingly sign a false or misleading financial report.
Representative Marchant.
Thank you. This legislation that has been filed today represents what America and especially what Texans have asked for from its corporate citizens, and that's accountability. There's two aspects of our legislation that are especially important for us to recognize. This legislation will give certain agencies, the AG's office, the State Securities Board, the Department of Insurance, the Board of Public Accountancy, and the PUC, the power to share information during investigations and still maintain a necessary level of confidentiality. Also, this bill will prohibit investment managers and advisors from doing business with the state that do business with the state from having any hidden client relationship with other businesses that could influence their recommendations. These steps are necessary to ensure that Texans can expect accountability from their government and from their corporations. This time, I would like to introduce to you Denny Crawford, who is the Texas Securities Commissioner.
Good morning, and thank you very much. My name is Denny Crawford, and I've got a very bad cold this morning, so you'll have to forgive me. First of all, I, like the Attorney General, want to thank these gentlemen for introducing this legislation, which is extremely critical going forward. And I want to run through very briefly what it does from a securities regulatory standpoint. First of all, we know that criminals do not recognize borders. This legislation will allow us, from the law enforcement perspective, to have reciprocal subpoena power to make sure that ongoing frauds that cross state lines will be addressed. Secondly, with regard to corporate insiders who abuse the trust of the investors and the corporations for whom they work, this legislation gives a very powerful tool to the Attorney General to ask for disgorgement under the Texas Securities Act. We think that it's vitally important that these people who abuse the public trust actually be required to disgorge the profits from those activities. The other thing that this legislation does is it addresses a situation where you have an unlicensed investment advisor. Unlicensed investment advisors should go to jail, and that's exactly what this legislation will do. It will allow us to put them in jail. And the last one that I want to talk about has to do with a technological issue. It shouldn't matter whether a security is in the form of a paper certificate or if it's an entry on a computer screen. A security is a security is a security. And this legislation will recognize the new technologies that allow for securities to not take the form of paper and will allow us as the law enforcement people in the securities area to address problems even if the securities are in technological form. Again, I want to commend you gentlemen for following this legislation, and I look forward very much to working with the Attorney General with the new Corporate Integrity Unit. The State Securities Board and the Attorney General have always had a good working relationship, as you in this room know, and we think it's going to be strengthened even more through this legislation. Thank you.
Well, I just want to add that I think our being here today shows that this legislation has strong bipartisan support. These are reforms that Republicans want, Democrats want, the people of Texas want, and we're going to do as much as we can to deliver it. In putting together the legislation, I think my staff and the Attorney General staff and Representative Martian's staff looked at things that were said during the various corporate scandals. While all of us were out on the campaign trail, even if we didn't have opponents, General, or even if we were helping some of your opponents, but commitments were made, things were said, and our staff got together and sort of put together a laundry list and looked around the country to see what other reforms were coming about. I think the Securities Board and the Texas Attorney General in particular are critical. I think there's a reason why so many of the investigations post-Enron came out of New York. Elliot Spitzer has considerably more power over a number of these areas than the Attorney General of Texas. Other states are trying to enhance the powers of their Attorney General, and I, quite frankly, am glad being a Democrat. I think it shows the bipartisan nature of this. I want to do as much as I can to give our Attorney General and our Securities Board the tools that they need so that if this ever happens again, we're not all just wrenching our hands and trying to figure out who can do something. We're more than happy to try and answer any questions that you might have.
So what exactly become new crimes under the legislation?
Oh, well, one of the new crimes has to do with investment advisors. These are so-called financial planners who currently must be licensed under the Texas Securities Act. But if they are not licensed under the current law, there is no criminal liability for the failure to license. So this law would create that.
And you'd add to that, well, we're going to impose a state jail felony from 180 days to 2 years on corporate officials found guilty of knowingly signing a false or misleading financial statement. And look, one of the big parts of it is the ability to coordinate efforts in the Attorney General's office in Texas, which is something that we did not have in the past.
Why not go ahead and give them the power that Elliott Spitzer has in New York?
Well, I'm coming as close as I can think of. I mean, and as this bill goes through the process, if we find out that Elliott Spitzer has any additional powers we're not given to him, that's the intent behind this. So if there's anything else that Spitzer has that Abbott doesn't have, I darn sure plan to do my best to give it to him.
I mean, isn't this just giving him the power to help the DA?
No, I think it gives him, I think it gives him essentially all of the tools that the Attorney General of the state of New York has. Now, you know, in my other life, I am an investment banker. Probably also the fact that most of those investment banking houses are based in New York gives you a little added leverage if you are the Attorney General of New York. But our intent is to give him all of the powers that the AG of the state of New York has. And I think we're doing that in this.
Does the Attorney General under this law have the ability to go after these people without local law enforcement, or is your hands tied to only aiding an investigation?
I'll let you take the first crack.
In my mind, obviously there's a role that local district attorneys have to play. And in no way will we take that power away from them. But I think this significantly enhances the hands of the Attorney General of Texas.
So they still have to have locals go after it.
Yeah, most things you do.
If you're invited, that's the same as you had in criminal questions now. You don't investigate unless you're invited. Is that what it's structured?
I wonder if I could try to address that. In the securities area, we bring securities criminal cases all the time, hundreds of cases. And the way it works is we investigate the cases, and then we have working relationships with the district attorneys across the state. I think that what's envisioned, and correct me if I'm wrong, is that the Attorney General would do that same sort of work in regard to corporate malfeasance to make sure that there is corporate integrity in the state of Texas. So it would be a relationship between the Attorney General's office and those DAs across the state.
Are these DAs actively pursuing these kinds of cases?
I think they're very interested in doing so, but you've got to have those legal tools before you can pursue these cases. Just as you've got to have the legal tools in the Securities Act, which we have, we've never had those tools in the corporate malfeasance area until this legislation.
Your legislation seems to be tailored to a certain extent as a follower of Sarbanes-Oxley. There are some in corporate governance areas who feel that Sarbanes-Oxley is a little too late. How would you address that?
Well, there may be some would say it's too little, too late, but it's certainly much more than we had by way of tools before it passed. And if, as we go through the process, I mean, other than the four of us, there's been very little discussion in this building about a legislative solution. But if there are others who come forward once they read about this, and we can enhance this legislation, I mean, we're below the 100-day mark, so things are moving quick. So it's opportunity to move forward. So it's a start. I mean, if there are others who have other ideas along the way, we looked, did a data search of any of the bills that were being talked about. No other bills have been put in. But if there are other ideas along the way that enhance it, we'll do it. And we've looked as best we can at the other states. New York just tends to be the model that you look at. Obviously, the local prosecutors have a role to play. You would want to do anything that would discourage corporations from coming into Texas if it looked like you were having a feeding frenzy on who could get to somebody first. But if there is malfeasance, we want to make sure on the state level that we have all the tools we can to combat it.
General, would you like this to go further? Would you like to have more authority than this bill gives you?
First of all, I'm thankful for the authority this does give me, and I'm looking forward to using the tools this provides to see what we can do.
A big part of the language in the bill, I think you have it there, where the Attorney General may seek disgorgement of any economic benefit gained by the defendant through the violation, including a bonus, fee, compensation, or option proceeds, profit from a loss avoided through the sale of a security or any other tangible benefit. It scared the hell out of me. I mean, that's pretty pretty potent too. Now, there may be others where just going doesn't bother them, but it tends to bother me.
I'll tell you, that's a huge step forward. And that's the key to what's been lacking in Texas law, is this ability to go after those individuals who have engaged in corporate malfeasance.
How do you think the Enron scandal, for example, would have played out differently if this legislation had been on the books?
If I was that smart, somebody would have hired me to defend them instead of me carrying legislation. I mean, I just, I don't want to go back and go in and go through the intricacies of the Enron scandal again. I'm just glad I never did any work for them.
Do you think this would, you would have, would there be a qualitative difference in the way that played out?
Well, I may make difference to others. There is if you look at what's called Section 2252.904 concerning contracts with companies, financial disclosures, et cetera, it's my understanding that Enron had some contracts with the state of Texas. This might have required financial disclosures over and above what existed in the past, and which would have given us a better opportunity to monitor what was going on in this situation, and might have been able to allow us to discern some advance notice of what some of the problems were. So yeah, my hope is as I read the bill, it will give us some new tools to try to prevent Enron debacles from occurring in the future.
I just noticed from my notes that attorney generals, you made reference to Sarbanes-Oxley, AGs and legislators in New York, California, North Carolina, Oregon, Illinois, Kansas, Ohio, and Pennsylvania have pushed for more concentrated state regulation and enhanced penalties for corporations that falsify or tamper with records or embezzle funds. So we're very much in line with what other states are doing after Sarbanes-Oxley. I also notice here that the combined loss from Texas funds, TRS, ERS, UTIMCO, and the public school fund came to about $277 million as a result of WorldCom and other profit scams.
I would be there. So if an Enron whistleblower walked into an AG's door and this legislation, what could happen in terms of investigation and prosecution?
My interpretation of the proposal as it currently exists is that if a whistleblower walked into the Attorney General's office, the Attorney General would have the ability to commence an investigation of the issue. Now, the way I think this is intended to work and the way that I would want it to work is to do that in conjunction with a local DA, and in this instance, maybe several various different local prosecutors, as well as other state agencies. One of the intents and purposes behind this bill is to have multiple law enforcement authorities to work in collaboration, as opposed to dividing it up into segments of 5 different entities or officials with the ability to shoot at an object. We can now all work collaboratively together.
And I agree with that. I mean, our intent is not to create the 255th District Attorney's Office in the state of Texas. We do pretty good with the 254 we have. But it gives us, from the state perspective, the ability to coordinate those efforts. And he certainly will have the ability to go in and investigate it. Now, he could make his decision as to which local district attorney he concentrated his efforts with when it's time to go to court, or he take it to the feds.
What kind of abuses are you trying to get at with the financial planner? What specifically are you at?
One of the things that we're worried about is financial planners who are not properly licensed and who don't undergo the necessary law enforcement background checks and demonstrate that they have a minimum competency level, which is what the licensing approach is all about. And right now, we're seeing instances where people just hang out a shingle and they say that they're a financial planner and they aren't licensed.
I understand, but most of the financial planners I've heard about are dealing with private individuals, not corporations.
No,
Is that not true?
no.
Which one of these people sit together?
Oh, yes, absolutely, yes. And also you have financial planners that advise the state pension funds, for example, All of those folks need to be appropriately licensed.
Why on earth would one of the state pension funds be using their own license financial?
Well, they wouldn't do it intentionally. Well, what we're concerned about is that someone could, and then those individuals would not go to jail if they did. So we want to make sure that there's criminal liability on the part of the people who are holding themselves out as investment advisors but aren't registered as such.
So is there a specific instance of a state pension fund or fund that is used?
You have to ask them.
You'd have to talk to them about that.
Is there a federal provision on the disgorgement issue? I mean, does federal law allow for disgorgement of property?
I think it does. I'd be surprised if it didn't.
So who gets the money?
On our bill? I hope we get it. No, but it's a big step in the right direction. I mean, I don't think that, someone asked about Sarbanes-Oxley. I mean, as you go through the process, obviously we can improve and enhance the bill, but you know, it's a step in the right direction. I mean, as complicated as the financial scandals were over the last couple of years, I don't think anybody would say that one piece of legislation in any state or in the federal government is the end all. I mean, you're talking about highly sophisticated individuals who get trained at the best schools in the country to figure out how to get around the rules. And as that happens, it's an evolving process.
Mr. Attorney General, as the Senator just said, there's some fairly sophisticated folks and fairly complicated schemes that were at play in recent past. Do you get an opportunity to get added staff, or do you get more sophisticated folks to come work for you under this bill?
Hopefully so. I think that we will need additional folks, how many I can't tell you, to ensure that the mandates of this law are carried out effectively.
And these would be investigators or attorneys who are knowledgeable or already have experience
Both.
in financial?
Both investigators and attorneys.
And where would you get these folks from, sir?
We always get the folks from the best and brightest around the state of Texas.
And when you allude to FTEs, I want to point out in New York, I know where the money went from disgorgement or the penalties that were assessed. They went to the state of New York. So I don't anticipate any cost to this bill, because when you give the Attorney General additional powers, you create an opportunity, if that's a malfeasance, to bring in revenue to pay for it.